The chair calls JoAl Sheridan. And I may have mangled your name.
No, you actually did it perfectly. Thank you. That's in 52 years, that's one of about 4 times. Thank you. I am JoAl Cannon Sheridan. I'm honored to be in front of the committee today. I am testifying on behalf of myself as a board-certified family lawyer in Texas and as the immediate past president of the Texas Family Law Foundation, and I am testifying in favor of House Bill 575. We are very grateful for Chair Dutton for carrying this bill. I am a lawyer who handles child-related cases regularly. One day I may be at the courthouse representing Dad, another day it may be Mom, another day it may be as the amicus for the children, and sometimes it's a grandparent or another family member. As a lawyer who handles these regularly, I'm going to tell you that my experience with these particular cases, when a grandparent comes into my office, I have to tell them that it is easier for a grandparent in Texas to get some sort of custodial rights of their grandchildren rather than just see them on some sort of visitation basis. And I feel that's a tragedy. Now, what I think Chair Dutton has let you know and what he's sought to do here is the current law as we have it basically says that, first of all, a grandparent has to show that there would be a significant impairment to the physical health or emotional well-being of a child if they are denied access to their grandparents. But that's not enough. They also have to show that they are the parent of a child who's either in jail, incompetent, is dead, or otherwise doesn't have a court order. Right now, what this bill would do, it would eliminate the implied requirements that you would have to have expert testimony, first of all, to have standing. And again, we're not saying that you necessarily get the relief you're seeking. It's just that do you have the ability to get in that courtroom and ask for it? There is a case in Ray Scheller that unfortunately I'm very familiar with where the Supreme Court implied that expert testimony is required, which you're just not going to have. And I would point out as a lawyer for the state of Texas, or in the state of Texas, that lay testimony has historically been sufficient to testify to the value of your property, for a court to consider in granting custody, to send someone to death row, but somehow now there's this implication it's not sufficient whether or not a court can order access, not custody, but just access to a grandparent. And they still have that high burden of significant impairment. The other thing this bill would do, it would eliminate those 4 prongs I talked to you about, because it seems that it's not a good policy to single out one group of kids who, just because their parent isn't dead or in jail or incompetent or otherwise doesn't have an order, if they're going to be significantly impaired by not seeing their grandparents, why shouldn't they have the opportunity to do so? Access doesn't mean a regular visitation schedule like a parent. It doesn't mean decision-making ability. What it does mean, if a grandparent can show a meaningful, long-standing relationship that should merit access, and it's being unilaterally denied to the detriment of a child, the court can order access, as little as FaceTime or emails, or as much as some birthdays, a week in the summer, whatever that court feels is appropriate under the circumstances, which may be different for every family. It's not a one-size-fits-all. Families are complex, and we would just like the statute to reflect that, and that it doesn't fit one size fits all, and that it recognizes the importance of these relationships, of parents' rights, as well as the best interest of the children and what those relationships with others are. And I'm happy to welcome any questions.
Thank you, Ms. Sheridan. Members, are there any questions? Thank you for
Thank you so
testifying
much
today.
Thank you.